So in the past week, we have seen so many stories of people getting fired over social media posts after the death of Charlie Kirk. But here's why a Supreme Court ruling from almost 4 decades ago could help some of these people get their jobs back. So the case is out of 1987. It's Rankin versus McPherson, and it goes back to events of 1981. Ardith McPherson worked in the Harris County Constable's office. That's down near Houston. So when John Hinckley Jr. attempted to assassinate Ronald Reagan, she remarked, "If they go for him again, I hope they get him." Well, somebody overheard it, reported it to her boss, who was Constable Rankin, and he fired her. Now, I think we can all see why her boss may have taken issue with what she had to say, but where do her rights of free speech end and her employer, the government's, rights begin? Well, she sued. The first court ruled against her, but after some back and forth, the appeals court reversed that ruling, saying that she had weighed in on a matter of public concern and that her rights of free speech outweighed the state's interest of efficiency and discipline in the workplace. This went all the way up to the Supreme Court. It took years until 1987 when the justices decided that even though the state does have the right to hire and fire people, it cannot fire someone just because it doesn't like the opinion they express. So basically, they had to weigh McPherson's right to free speech, the First Amendment, against the state's rights and her ability to do her job effectively. So in doing so, they looked at a few different criteria, whether this was over a matter of public concern, the nature that her remarks would be heard widespread, whether or not they were likely to incite violence, and just how reasonable the argument that those remarks would limit her ability to do her job. So what does that mean for today? Well, this applies to public employees, not private. So if you are a public school teacher, a professor at a public state university, a city government worker, anybody who is employed by an arm of the government, this applies to you. Depending upon which court you appeal to, that Supreme Court precedents would come into play. So for instance, let's say there's an elementary school teacher who posted on her private Facebook page, right? What are the odds that her elementary school students would see that personal Facebook page comment? Is there a reasonable expectation that it would affect her ability to teach those kids? Was it a direct threat or just a post that was critical of Charlie Kirk? Did her employers only find out about it because somebody used it to try and get her fired? Even the things like, what did her employer say before firing her? Is it just because they want to blanket crack down on criticism, or is there a real issue with what that person said and their ability to do their jobs afterward? So what are your thoughts here? Where do you think the line should be between free speech and a government being able to fire someone as consequences for their speech?